Hi guys, welcome to my channel. Today we're seeing about the SARFAESI Act for the IBPS and SBI PO, and today the topic is enforcement of security interest. So the particular section that we are going to discuss now, it is the heart and soul of the SARFAESI Act. It is the it is this section that makes the SARFAESI Act what it is. Like I said, the SARFAESI Act is an act which gives the bankers and financial institutions unbridled power to enforce the security, that is a mortgage or hypothecation, without the intervention of the courts. So all these are in this particular section, that is section 13. So let's look into it. What are the things that we are going to see today? We're going to see how the enforcement without court takes place, that is the core power, and the 60-day demand notice, that is the first step in the SARFAESI action. After an NPA is declared, it is the 60-day demand notice. Then there is going to be a borrower's representation. This is a new thing where the borrower has the power to represent, added after the Mardia chemicals case. Then what are the measures on default that could be taken by the bank or financial institution? And what is the remedy in joint or consortium actions? So joint or consortium actions are another unique topic where multiple banks come together to fund a borrower or a project. Then if it fails or if they default, how would they actually enforce the security interest? So let's go to the most important core power under SARFAESI, that is enforcement without a court. So a security enforced can be enforced by the secured creditor without the intervention of the court or tribunal. This operates despite sections 69 and 69A of TP Act, which says that to sell a mortgage property by the mortgagee, you need court's permission. So SARFAESI Act is what that gives the bank the power to sell their property. Of course, mortgage is not the only aspect in SARFAESI, but nevertheless, that is the most important security, that is mortgage of an immovable property. Of course, there are other movable properties like book debts, receivables, car, plant and machinery, but uh, mortgage is a significant, uh, or it's seen as a primary security by the banks or financial institutions. Next, moving on, the most important thing is the 60-day demand notice, that is called as a Section 13(2) notice. This is actually issued by the authorized officer who is at least in the rank of scale 4 and above, that is a chief manager. So it applies when the borrower defaults in accordance with NPA. They issue a demand notice. The demand notice is you have 60 days time. The security say the secured creditor issues a demand notice for 60 days, and if after 60 days the dues are unpaid, then they can actually take enforcement action under sections 13(4). So that 60-day demand notice is very important, and it also has very elaborate, the section 13(3) gives you the elaborate details on what should be there in the demand notice. The demand notice is one of the most crucial piece of notices that you must design, because any mistakes in demand notice can be challenged by the borrower in the DRT, and can be challenged by the borrower in the DRT. And yeah, so it's very important that the authorized officer who issues us the demand notice gives uh, 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 does a proper due diligence before issuing it. So it must state the amount payable by the borrower. So we have to be very careful. You have to look into the interest component. You have to see whether it has been properly issued or not, and the details of the secured assets, and if it is debt securities, about the borrowers, and all these things are very important. So it has to include the details of the secured assets, the details of the loan, the details of the borrower outstanding dues. All this must be properly issued in the demand notice. Now this is another important section which you must remember. And the point is, on receiving a 60 days notice, within that 60 days, the borrower can make a representation under section 3A. They can actually make a representation. And remember, the power is only a representation. And once the borrower makes the representation, it is the responsibility of the bank or the financial institution to reply within 15 days of the representation. And in case if you have not done within 15 days, then that can invalidate the SARFAESI action. So this is very important power. Look, the representation can be anything. The bank can actually reject the representation. The bank can say no, anything, but you must reply to the representations. Just not replying to the representation would be seen as a serious violation, and it can actually invalidate the SARFAESI proceedings. Look, SARFAESI Act is an act of procedure, and this, since the act tries to deprive a person of a property, remember, is actually a constitutional right. It was actually a fundamental right, now it's a constitutional right. So depriving someone of a property which is seen as one of the important core rights, and without a court intervention, the bank has to be at the top. They should ensure proper due diligence is done. Any silly mistakes in these procedures, the DRT or the High Court or the Supreme Court can invalidate the recovery action. So this, like I said, the most important thing is the 15 days point. You must understand it very thoroughly. 15 days is very important once the borrower makes the representation, and it is inserted after the famous Mardia chemical Mardia Chemicals versus Union of India case, uh, 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 where it was actually it was actually uh, decided by the court that SARFAESI Act is not unconstitutional. And the other thing is that, see, this is just an optional remedy, and just because if it is not it is not exercised by the borrower, if it is not exercised, and if at any stage if the borrower is aggrieved, then they can actually go to DRT. But this is an optional, and usually every borrower, if they want to give a representation, they would do so, because recovery action is a time-consuming process for the banks. The banks would always want to recover the money, and if the borrower pays uh, and try and do some kind of one-time settlement, then it is actually a win-win situation for both the lender and the borrower. Now, measures on default, like after section 32 notice, after 60 days, after all the borrower has exhausted his representations, if the dues are unpaid, then the secured creditor can do any one. They can actually take the possession of the secured properties. If they have a mortgage of an immovable property, they can take the possession. They have the right to lease or assign or sell them. And if it is a business, they have the right to take over the management, and they can also appoint a manager to manage the secured actions taken possession of. And they can also recover from third parties who owes money to the borrower to pay the credit. So they can actually write to the third parties who has to give money to the borrower to directly fulfill the debt of the uh, bank. So these are the measures. And this is another important rule that you can remember, the consortium and the 60% rule. When a financial assistance is given by more than one secured creditor, uh, or no single secured creditor can act alone, and the majority, the consensus is 60 percentage. The consensus, remember, is 60 percentage. The consensus is 60 percentage, and you can always compare and contrast it with IBC, where there are committee of creditors. Remember, that is not consortium, committee of creditors, where there are multiple secured creditors. Then 66 percentage is required for voting or approval of the resolution plan. So forget about that now. It's about 60 percentage for the consortium rule. That's the most important thing. Now, a quick recap, and remember, the thing is, Uh, Section 13.1 says enforcement without the court, overriding the TP Act, that is Transfer of Property Act, and Section 69 and 69A, and a 60-day demand notice. And within 60 days, if the borrower makes a representation, the secured creditor, that is the lender or the bank or financial institution, has to reply within 15 days. And if the 15 days period is not done, then the court can actually invalidate the action taken by the financial institution. Then there can be a representation under 13A that we discussed a little bit before, and 13.4 is based on possession. And what is they can take the possession, or if it's a company, they can appoint a manager, management, take all the management, etc. And 60% of the secured creditors' consent is required in case of consortium uh, filing. So the test yourself question says that under section 13.2, the demand notice gives borrower how many days to pay? That is that 60 days. With this, we can come to the conclusion of today's topic, and tomorrow we'll see the possession, sale, and waterfall. That is elaborately how a symbolic or physical possession or the right to redemption, all these things happen. So that is in the next chapter, next video. So if you like this video, do share, like, and subscribe to my channel. And if anybody is preparing for the examination, please share it with them. And if you have any doubt, please put it in the comment box. And if you want any title that I need to address, put it in the comment box. I will read each and every comment. Thank you.